we're going to go to later. What you say?
731.
731.
Chair lays out Senate Bill 731 and recognizes its author, Senator Harris.
Members, this bill, Senate Bill 731, addresses the concern of an attorney not telling their client about a structured settlement offer because he will get a bigger fee or quicker payment from a lump sum settlement. It requires it not only addresses the personal attorney, but it's also meant to raise the question and address the question as far as an attorney ad litem who may have also been appointed in the case. It requires a structured settlement offer to be made in writing from the defendant to the attorney for the plaintiff, and if the suit is on behalf of an injured person, an attorney representing that person as soon as practical after getting the settlement offer, but before it expires, the attorney has to tell the injured person or their personal representatives that the offer's been made. It also requires that if there's a guardian ad litem, their duty must be to the injured person. It establishes that the guardian ad litem has a fiduciary duty of integrity, loyalty, and the utmost good faith to the client. Finally, if the guardian ad litem is not adequately performing his duties, or if it would be in the best interest of the injured person, the next friend may make application to the court for the appointment of attorney ad litem. And that's basically what the bill has, Mr. Chairman.
We have 3 witnesses. Josephine Grillo. You identify yourself.
Yes, sir. My name is Josephine Grillo. To the members of the Jurisprudence Committee in the 76th legislative session, I thank you for the opportunity to address you here today. I will speak towards the need for legislation outlining the duties of a guardian ad litem and how the failure to discharge those duties can have devastating effects on their client's well-being. While Mr. Sullivan will be detailing the cost to the citizens of the great state of Texas, as well as the impact on an individual for the failure to structure a personal injury settlement properly. If a guardian ad litem has been appointed by the court to participate in the case to the extent necessary to adequately protect the interest of a minor or incompetent, the guardian ad litem's fiduciary duty to the minor or incompetent is one of integrity, loyalty, and the utmost good faith. In Senate Bill 731, I believe we are all working towards effective legislation that will assist to inform the citizens of Texas by placing into law Senate Bill 731. Section 139.051 of Senate Bill 731, Applications of Next Friend. On the application of the next friend of the claimant, a court may order the appointment of an attorney ad litem for the claimant if the court finds that 1, guardian ad litem appointed for the claimant is not adequately performing the guardian's duties on behalf of the claimant, or 2, the claimant would otherwise be benefited by the appointment of the attorney ad litem. This section of the legislation is of particular importance because the guardian ad litem replaces the guardian or next friend in a legal proceeding to represent the best interests of the child or mentally incompetent individual. If the guardian ad litem fails to discharge his duties, responsibilities, then that should be brought to the attention of the trial court, at which time the judge can reappoint a guardian ad litem or appoint an attorney ad litem to serve currently. No child or individual should not be allowed due process under the law, but by replacing the guardian or parent is an ongoing proceeding leaves the guardian or parent without the right to seek proper representation for their child because they have been replaced. Section 139.103, Duties of Guardian Ad Litem. A guardian ad litem who has been appointed by the court to participate in the case is necessary to protect the interest of the claimant. Number one, owes to the claimant a fiduciary duty of integrity, loyalty, and the utmost good faith. And number two, shall obtain before any structured settlement offer is accepted competent counsel from a person qualified to A, analyze and explain structured settlement offers, and B, make suggestions for tailoring the structured settlement to meet the needs of the claimant. Former president of the Texas Trial Lawyers Association, Mike Slack, stated that the TTLA did not want to see the money spent needlessly, that this is the one provision in the legislation that troubled the Texas trial lawyers. At this point in litigation, many times tens of thousands of dollars have been spent by the plaintiff in order to achieve a favorable result, and at one of the most critical points in the litigation, someone would not want to make sure that the settlement proceeds are placed to their highest and best use. If a structured settlement broker is utilized, then they do not charge a fee to the plaintiff or the defendants. Their fee is derived from the annuity company that the structured settlement is placed with and is paid as commission to the broker. Structured settlement annuities are a highly specialized financial instrument requiring the service of a person who is licensed and trained in this narrow field of expertise. In your booklet that has been provided to you, and in Section 2, Court of Appeals, 2nd District of Texas involves a recent decision issued January 14, 1999, that the guardian ad litem and a minor have a formal relationship of confidence. An ad litem is an officer appointed by the court to assist in properly protecting the child's interest. The ad litem has a duty to conduct a thorough investigation and evaluate, number one, the damages suffered by the minor, number two, the adequacy of the settlement, and number three, the proposed apportionment of settlement proceedings among the interested parties. Number four, the proposed disbursement of the settlement proceeds, and number five, the amount of attorney fees charged by the minor's attorney. The Second Court of Appeals also found that under Rule 173, the guardian ad litem is not protected by judicial immunity because to do so would give the minor no recourse for an inadequate representation of his or her interest. The court held that when a guardian ad litem who has replaced the next friend under Rule 173 can be held liable in a civil action for damages resulting from a breach of his duties as a personal representative of the minor. In your booklet in Section 5, Houston Bar Association represents Civil Court ad litem Harris County Jury Assembly on April 12, 1996. That was 12 to 5 p.m. MCLE credit, 4.75 hours. It is a fairly comprehensive outline detailing the role and duties of guardian ad litem. Judges should limit appointments to the individuals who have completed a continuing legal education course specific to the role, duties, and obligations of a guardian ad litem. In your booklet in Section 7, the Court of Appeals, 5th District of Texas at Dallas, dismissed an appeal brought by the parents because the parent had no standing to bring about the appeal, because they had been replaced by the guardian ad litem. Therefore, it is a lax subject matter and was dismissed. This opinion gives rise to Section 139.051, whereupon application of next friend of the claimant, a court may order the appointment of an attorney ad litem for the claimant. In your booklet, Section 11, Senate Bill Number 586, Guardianship Advisory Board, became effective September 1, 1997. Originally, the proposed Senate bill would have required all attorneys representing parties in guardianship proceedings, not just attorney ad litems, to take the 4-hour certification course now required only of attorney ad litems. The requirement was deleted and the law on this point remains the same. If certification is required in guardianship proceedings, then why is it that we do not have the same standard in the trial court? If a guardian ad litem is appointed who has not completed certification, then we have not adequately protected the citizens of Texas. At present, this is not part of Senate Bill 731, and I have not found any pending legislation, but I strongly believe that certification is needed before a guardian ad litem or attorney ad litem is ever appointed in a civil action involving a minor or non-compos mentis individual. No parent, guardian, or next friend should have to fear the court system because of inadequate representation. The guardian ad litem has a fiduciary duty to look out for the best interest of their client. If deficiencies exist under the law, then it is up to each and every one of us present today to ensure the well-being of the citizens of Texas and send the legislation to the Senate for approval. I am now going to turn over the testimony to Mr. Sullivan at your request, who will speak about the economic impact to Texas. And once again, always Senator Harris, Senator Wentworth, Senator Brown, thank you very much. Senator Luna.
Craig Sullivan is recognized. Identify yourself.
Thank you, Chair. My name is Craig Sullivan. I'm here to speak in regards to Senate Bill 731. What I would like to detail primarily is things we have discussed and touched upon in the past, but really hadn't brought to light to where the committee could truly see it. In Section 12, in the booklet provided for you, is an affidavit by Vincent Appilato, Ph.D., where he details the structured settlement that was offered to Christina back in 1990 in several different fashions. One, if $1 million were structured, if $1,267,579 was structured, if $1,413,272, and $1,613,898. The reason we represent these figures is if $1 million were structured, the present day dollar value to replace that today would be $11 million to duplicate that same structure that could have been purchased back in 1990. To the actual structure that was offered to Christina but never conveyed would cost today $13,984,088. If the full amount that Christina and Josephine received of $1,413,272 would have been structured, that would cost to replace at $15,665,764. And I call this last number to reference if attorneys would have taken a 33 1/3 attorney fee in this case, as brought out by probate code, they took a 40% fee in the case off the gross settlement. There would have been $1,613,898 structure, but present day dollar value of $17,966,158. What this is representing to the taxpayers of Texas and to the citizens of Texas is devastating. Christina, by virtue of not structuring the money, when she turns 18, she will be out of funds. Under a structured settlement, utilizing the financial instrument, that would have been based on her life care plan, looking after her needs over the course of her life. And in section, if we go to section actual 13, there is a copy of the letter detailing that $1,267,579 would have purchased an income stream starting back in October of 1990 of $6,641.84 per month, increasing at 7.2% per annum on her 18th birthday, going to $20,087 per month, increasing at 7.2% for life. This structured settlement, ladies and gentlemen, members of the committee, the structured settlement itself, as it followed Christina's life care plan in section 15, is detailed by Dr. Robert Voigt, calls for over $240 million to be expensed over Christina's lifetime. That $1,267,579 would have covered that $245 million. Now, as it stands, that $245 million, when on her 18th birthday, if she is out of funds, there will be no other courses but to seek possible state and federal assistance through Medicaid, Medicare programs, which will burden the state at that point in time when she had an opportunity to be self-sufficient. And what we have found in our investigations and talking with other people, what happens, this goes on daily. This is costing Texas now hundreds of millions of dollars by failure of not structuring a settlement properly for an individual who's been personally injured. I appreciate your time. Thank you.
Thank you.
Thank you both very much.